Tēnā koutou e te whānau a te apārangi. Ko Amokura Kawharu tōku ingoa, kei te mihi, kei te mihi, kei te mihi. Kia ora koutou, my name is Amokura Kawharu. I have backgrounds in commercial and international law, and I specialise in a type of dispute resolution called arbitration. In essence, arbitration involves parties agreeing to submit a dispute between them to a tribunal, which they appoint for resolution. That tribunal is impartial. It must give the parties an opportunity to be heard, and the tribunal has to give a reasoned decision, which is then binding on the parties. I also undertake work in relation to Te Tiriti o Waitangi and tikanga Māori. We have wonderful opportunities to consider the intersections between knowledge systems that exist in Aotearoa and how each may enrich the other. For myself, I also consider this to be an obligation as we continue to deal with the ongoing impacts of colonisation, which include the imposition of colonial law on Māori. So this brings me to my question that I want to discuss today. Is arbitration a model for Māori dispute resolution? Does it make sense to draw on commercial dispute resolution law principles to help address problems and disputes arising within Te Ao Māori? This question is part of a wider picture of Māori social, economic and legal development. Treaty settlements, resource management and claims to customary marine areas have reignited age-old disputes about who has mana whenua and who has mana moana. Treaty settlements have also prompted increasing economic interactions among Māori and the creation of new governance arrangements. Much of this activity needs to be supported by dispute resolution mechanisms of some sort in order to be effective. The problem giving rise to my question is this. If parties want their dispute to be determined in accordance with tikanga Māori, then any tikanga process they undertake can be undermined by any one of the parties deciding instead to go to court, because all of us have the automatic right to take disputes to court and resolve them through litigation. However, this is subject to an exception. If parties choose arbitration, then any litigation will be stayed. It will not be allowed to proceed. This is because arbitration is a binding alternative. It is the only binding alternative to litigation in the courts. So why arbitration? The argument for arbitration as a model for Māori dispute resolution begins with the liberation of Māori law. One of the impacts of colonisation has been our inability to source our right to do anything in the rules of our own law. Now, we are seeing increased awareness of tikanga Māori and its associated kawa as being Māori law, and increased acceptance of it within state law. But there are still difficulties and hurdles to that acceptance. In arbitration, this problem simply doesn't arise because arbitration law allows parties to choose to apply any law to their relationship, including non-state law such as tikanga. A further hallmark of arbitration is that the parties have wide freedom to choose their own procedure, subject only to minimum natural justice protections. So this means in this context that parties could, for example, locate their hearing at a marae and choose to conduct the entire proceedings in Te Reo Māori. This would have a number of advantages. For example, it would enable community participation. This is important because the community is responsible for upholding communal values and its mana may be at stake. It can enable respect for the meeting house, which is a repository of knowledge and whakapapa. This in turn can emphasise whakapapa accountability to past and future generations. Holding proceedings in this way can allow the parties to identify themselves in a way that supports their ongoing relationships. And finally, it can promote the effectiveness of outcomes. Decisions that are made on a marae tend to be given more weight than decisions made elsewhere for the reasons that I've just described. There are other procedural advantages to tikanga being used to help define arbitration procedures also. In a court proceeding, witnesses have to be sworn in. Swearing in is not necessary in an arbitration, so you do not, for example, have to ask respected elders to promise to tell the truth. The tribunal can simply make its own assessment of the evidence it hears. In an arbitration, it's normal for arbitrators to sit behind tables and face the parties, and so they can communicate directly with the parties face to face. It's possible for judges to do this too, but normally judges sit above, behind their benches. Yet arbitration does not yet enjoy widespread recognition in Te Ao Māori. It may be that we prefer the familiarity and the convenience of the court system. Arbitration can also be very expensive because the parties have to pay for the costs of the tribunal and the proceedings themselves. But a deeper concern may be that arbitration is fundamentally a Western approach to resolving disputes, and resolving disputes using such techniques like this and making them Māori friendly is not good enough. My initial response to this is that tikanga is adaptable. We should always remain open to accepting ideas from other cultures so as to sustain and develop our own. I've also examined the nature of the arbitral process and compared it with Māori dispute resolution approaches. I have found that arbitration is compatible with tikanga in at least some respects. For example, rangatira, or chiefs and leaders, had significant decision-making powers. But as with arbitrators, their authority was, and still is, dependent on principled, wise, and fair administration. Arbitration can promote rangatiratanga, kotahitanga, and whanaungatanga, or the exercise of Māori authority, self-determination, and unity. It can facilitate the achievement of ea, or finality, by resolving a dispute in a way that respects the mana of all parties, using some of the processes that I mentioned earlier. That said, and here I wish to conclude, for this to work, some things would need to change. The form of arbitration currently represented in our law is modelled on an international template for transnational commercial arbitration. To reflect a more for Māori, by Māori process, there are several topics for law reform, and I'll just give a couple of examples. There is currently a default rule in favour of strict confidentiality of arbitral proceedings. This seems impractical and contrary to the community orientation of Māori disputes to maintain the level of confidentiality required by this rule. We'd also need to develop guidance for managing conflicts of interest and for identifying which conflicts would disqualify a person from appointment as an arbitrator. It will be important to have this clarity given the traditional roles attached to Māori leadership and their kin accountabilities. So in sum, arbitration, I think, holds promise as a model for Māori dispute resolution. Working within the current legislative framework is sufficient, but not ideal. There are also capacity issues that will need to be addressed as part of the long-term rebuilding of Māori legal institutions, but those are for discussion on another day. Nō reira, tēnā koutou katoa.